Thank you for joining me today for an important webinar on transferring your assets to the trust, also known as trust funding. For those that haven't met me yet, my name is Andrei Jingan. I am a estate planning attorney based in California. Before we discuss why trust funding is important, we have to understand what trust funding is. Trust funding is the process of changing the ownership of your accounts and property to the trust during your lifetime, or designating the trust as the beneficiary or contingent beneficiary of an account or piece of property so that the trust will receive ownership at your passing. Some people find this step of the estate planning process to be a hassle and either forget to complete it or delay it until it is too late, unfortunately. While this is common, it can have some very drastic consequences for you and your loved ones. Creating a trust is like creating a bucket. You will place your accounts and property into that bucket, also known as funding the trust. Now, you no longer own those accounts and property. However, as the trustee, you continue to manage and invest the accounts and property. In addition, as the beneficiary, you continue to get the enjoyment of the accounts and property. The key difference is now the trust owns those accounts and property and not you. Because you do not own them, they will not go through probate upon your death. Should you forget to include an account or piece of property in your bucket, that item may end up going through probate if it's not jointly owned or controlled by a beneficiary designation. While the main focus for trust funding is usually on probate avoidance, by properly filling your bucket, you are taking the first step to making sure the trust administration process will go smoothly. First, when a trust is properly funded, your successor trustee will be able to access and manage the accounts and property more easily. This can be incredibly important if your successor trustee is stepping in because you are no longer able to manage your financial affairs. When that happens, you will want a quick and seamless transition in control. Also, by completely funding your trust and keeping your accounts up to date, you are helping your successor trustee complete one of the first major tasks he or she will have to do upon your death. As part of the trust administration process, your successor trustee will be required to put together an inventory of all the accounts and property that are part of your trust and distribute to the beneficiaries. If you have done your job in funding the trust, it will be easy for the trustee to determine what is a part of the trust and to quickly put together the inventory. Lastly, funding your trust ensures that your estate plan is carried out in the way you had intended. You are setting the stage for your trustee to come in and simply follow the instructions in the trust agreement. As mentioned before, if an item is left out of your trust, it may not be distributed as planned. It may be distributed to a different family member according to the state law, transferred to a named beneficiary on an old beneficiary designation, or automatically transferred to a joint owner. So now that you know what trust funding is, let's see what it takes to accomplish the trust funding. The first step in the process is to make a list of all your accounts and property that you own. You may have already done this step during the estate planning process. If so, you need to review that list to make sure that it is up to date. Have you acquired any new accounts and property since your estate planning documents were signed? Second, once you have a list of all your accounts and property, you need to refer to the paperwork to see how those accounts and property are owned and who is named as their beneficiary. Have you already made the necessary changes to your accounts and property? If not, you need to do so as soon as possible. This is also a great opportunity to review your estate planning documents to make sure that they still reflect your wishes. Next, if changes need to be made, they need to be made using the correct paperwork. You should contact the appropriate parties, such as banks, financial advisors, me, to complete the proper paperwork to either transfer the ownership or name the trust as the beneficiary, depending upon what has been discussed with your attorney. Lastly, the paperwork needs to be completed. Make sure that you receive confirmation from those institutions regarding your changes. The last thing we want is for your successor trustee to find out after your death that the insurance company never received the new beneficiary designation form. While everyone will own different types of accounts or property, there are some common items that are funded into your irrevocable living trust, of course after the creation of the trust itself. Sizable bank accounts or cash equivalents, including treasury bills, money market accounts, and certificates of deposit, can have their ownership changed by signing new signature or ownership cards. If you have a small joint or other checking account that you use primarily for your household expenses, these do not need to be changed as of now. However, there is caution. Before you retitle certificates of deposit, please consult with the bank officer to make sure that their institution does not consider the change in account name to be an early withdrawal that incurs a penalty. Brokerage or investment accounts can have their ownership changed by reaching out to your broker or custodian and asking them to change the title of those accounts to the name of your trust. If you have the original stock or bond certificates, you can transfer them to your trust in two ways. First, you could open a brokerage or investment account in the name of your trust and deposit the original certificates into that account. Second, you could work directly with a transfer agent for the stock or a bond and have the stock or bond reissued in the name of your trust. Although personal property such as household furnishings, works of art, jewelry, collections, books, do not have a piece of paper that shows their ownership, it is still possible to transfer the ownership to the trust through a personal property assignment. Transferring your real property to your trust will require attention to ownership and tax issues based on the nature of the property and the current title. Because there are many different types of real estate, it is important that we discuss what types you own to develop the best strategy for handling them in your estate planning. Each client's situation is unique. We do not take funding as a one-size-fits-all matter. During the estate planning process, we will or have discussed your planning objectives and the specific accounts and property you own. From there, we craft a plan that best accommodates these considerations to get you to your desired outcome. If you have any questions about whether a particular account or piece of property should be in your trust, please give me a call. As we just mentioned, there are some common items that should be transferred into a trust subject to your unique situation. At the same time, when it comes to what should not be placed in the trust, there are also some other items to consider. You should never transfer ownership of a qualified retirement or pension plan or individual retirement account to your revocable living trust. If, after consulting with us and your tax attorney, you have decided that it is best to have the retirement account as a part of your trust, only then you can name the trust as a beneficiary or a contingent beneficiary of that account. However, given the possible tax consequences involved with planning for retirement accounts, it is crucial that you evaluate your situation before any changes are made. Vehicles, boats, and other recreational vehicles can be added to a trust, but we find that most clients prefer not to include them in the trust during their lifetime. First, you have an accident. The fact that you have a revocable living trust listed as the owner could cause other parties to the accident to assume that you have deep pockets and encourage a lawsuit. Second, most states have a process for transferring a vehicle outside of the probate process, though some states do limit the number of vehicles that can be passed on to an heir or other beneficiary outside of a will. The first and one of the most important things you will need is the funding instructions form that we provide to our clients once the trust agreement has been signed. This document will provide you with a description of different types of accounts and properties, as well as instructions for how to go about changing the ownership. It will also alert you to any additional issues you need to be aware of before changing the ownership. Armed with your funding instructions form, you will need to obtain change of ownership forms from various institutions that you hold your accounts. Some institutions will mail or email them to you, while others may have the change of ownership forms available on their website. In some cases, you may have chosen to transfer the ownership of the account at your death through the issue of a beneficiary designation form. The institution holding your account can provide them to you through mail, email, or even sometimes on their website. An affidavit or a certificate of trust is a document that is prepared along with your revocable living trust, which states that your trust is in existence, you are one of the trustees, and you have the authority and power to transact business as a trustee. In some cases, when you change the ownership of an account, for example, an investment account, you may have to complete a new account application and present an affidavit or a certificate of trust. When transferring the ownership of real estate, regardless of the parties involved, a deed has been prepared. The preparation of the deed should be done by a state licensed attorney to ensure that all of the formalities are followed and the property is transferred in a correct way to fulfill your estate planning objectives. As you already understood, trust funding is an important part of the estate planning process and one that cannot be overlooked. Now is the time to make sure that your estate plan is truly complete. If you or your friends are ever in need of an estate planning attorney in California, please don't hesitate to reach out. I take great pride in my work and I promise to exceed your expectations. My contact information is included on this page, and to easily save it on your phone, simply scan the QR code from the screen.